a premium was placed and a priority was placed on intelligence gathering. An elaborate legal framework was developed to essentially justify the indefinite detention of people by the U.S. government in places like Guantanamo Bay and Bagram, Afghanistan, and their subjection to interrogation techniques that were unfettered by the traditional restraints that apply in the context of ordinary civilian law enforcement or to the treatment of prisoners of war under the law of armed conflict. And so the result of this process was the gathering of intelligence information statements by detainees that ultimately formed the basis for, in large part, for these military commission prosecutions. And given the circumstances that I've just described, you would imagine that the information taken from the detainees was not, by and large, taken with the precautions and protections that are normally afforded to criminal suspects to ensure that statements are reliable and probative when they're taken. They were taken under often brutal interrogation methods, almost necessarily always coercive and sometimes arguably amounting to torture. The result is a body of evidence that could not form the basis for a prosecution or conviction in any court in the United States, or I submit in Canada, or any place in the civilized world. And so it was necessary, if we were to have some final process for these people, to create a special trial system that would use relaxed rules of evidence and procedure that would allow convictions based on this unreliable evidence that could not be obtained elsewhere. And that's where the military commissions come from. Now, this process was initially commenced by executive order in an effort to involve the other branches of the U.S. government as little as possible. The detainees were taken to Guantanamo Bay, Cuba, which, for a number of reasons that I won't get into, was considered by the administration to have a special legal status that prevented the U.S. courts from reaching detainee habeas corpus or other actions that might be filed there. And the military commission process was instituted in the executive branch. Now, ultimately, the detainees did receive the grant of access to the federal courts after a case called Rasul v. Bush, decided in 2004. Following that case, there was a challenge to the legality of military commissions filed by Mr. Hamdan, who was one of the first detainees charged with so-called war crimes at Guantanamo Bay. Mr. Hamdan won his suit eventually in front of the Supreme Court, and in a decision in June of 2006, Hamdan v. Rumsfeld, the Supreme Court held that the military commission system instituted by the President was illegal. Now, why they did so is interesting. The 1949 Geneva Conventions are the backbone of the modern law of armed conflict. They generally apply to situations of interstate or international armed conflict. However, there is a provision common to all four Geneva Conventions that were done in 1949, Article 3, and therefore it's called Common Article 3, that basically says that even if you don't have a conflict that is otherwise covered by the conventions, certain minimum standards of protection apply and bind the parties to the conflict. Such onerous prohibitions like not murdering people, not torturing people, and not convicting them after show trials. And what the Supreme Court found was that the military commission system created by the executive branch failed to meet, in terms of its guarantees of fairness, even this most basic and fundamental level of protection provided by international law. And so as a result, the military commission process stopped. The administration was forced to go back to Congress and did so in the midst of a heated election season when no one wanted to be seen as being on the wrong side of the war on terror. And the Military Commissions Act of 2006 was the result. And that is the statute under which the military commissions are operating today, and it is the statute under which Omar Khadr is to be tried and has been charged. Now, as a result of this sequence of events, whatever else can be said about the Military Commissions Act, it is an entirely ex post facto or after the fact creation. Ordinarily, the law works, as we all know, you pass it ahead of time or ahead of the conduct that you're going to charge people with crimes based on, and you make up the rules ahead of time, generally. And here we didn't do that. So we have a body of offenses unknown to the law of armed conflict, and I believe Professor Robinson is going to talk about why that's so in a moment, that did not exist in the law until October 17, 2006. Yet the government is purporting to apply those offenses retroactively to conduct in Omar's case that occurred in 2002 and before. And it's not just the substantive offenses, it's the procedures. We're talking here not about some unknown set of cases out there in the future. We're talking about an existing body of cases with existing bodies of evidence. And the government has basically been able to sit down and design a trial process around its evidence. And it could literally, look at a proposed set of rules and say, if we write the hearsay rule to be A rather than B, we win. If we write it to be B, we lose. Well, guess what? We'll pick A, and that becomes the law. And so that's the type of system that is in place in Guantanamo Bay, and that Omar Khadr is to be tried by. And it is fundamentally unfair and an affront to the rule of law. This process, for obvious reasons, has drawn the ire of the international community, and what we've seen is that other countries, particularly Western countries whose citizens were subjected to the Guantanamo Bay regime, have stepped up to say this is not good enough for our citizens. We are not going to allow our citizens to be tried in this system, regardless of what they did. There are values and principles at stake that are simply too important. And so what we saw early on was that the United Kingdom engaged and said this process is unfair. We're going to call for the repatriation of our nationals to face due process at home. That request was ultimately respected. That call was recently extended by the United Kingdom to British residents, and there are currently ongoing negotiations between the United Kingdom and the United States for the return of British residents to Guantanamo Bay. Australia is another noteworthy example. It took them a little bit longer to come online. They demanded the release of Mahmoud Habib in 2005. David Hicks took a little bit longer, but ultimately the Australian public, through educational efforts such as the one that we're undertaking tonight, got sufficiently fed up with seeing their citizens treated this way that they said enough's enough, and compelled the John Howard government to intervene with the Department of Defense to obtain a favorable result for David Hicks that allowed him to return to Australia where he is today. And so we are hopeful that the Canadian government will soon follow this lead and take action to ensure that the rights of this young Canadian citizen are protected, because if the Canadian government doesn't act and the Canadian people don't act, I don't expect that anyone else will.
So next I'd like to introduce Professor Darryl Robinson. Darryl is my colleague at the University of Toronto Faculty of Law. He most recently was an advisor to the prosecutor of the International Criminal Court, and prior to that served for a number of years as a legal advisor on international human rights law and humanitarian law to the Canadian government. Currently at the Faculty of Law, he is the director of the Human Rights Clinic. Thanks, Darryl.
Bill has outlined for us some of the procedural problems, human rights problems, and constitutional problems in this situation. But there are also core issues of humanitarian law. So what I want to talk to you about these alleged crimes, the idea of an unlawful enemy combatant, and then also the treatment of child soldiers. Now, when we first heard reports of this firefight, we heard that Omar Khadr had thrown a grenade at a medic. And so what comes to mind is somebody with a stretcher that's tending the wounded. And certainly my thought was, well, that is reprehensible. That is a war crime. It turns out that the Bush administration had slightly distorted the facts uncharacteristically. Sergeant Spear had training as a medic, but at the moment of this firefight, he was a combatant. The Marines had blasted into the compound where Omar lived. They were entering the compound. Omar is wounded. From hiding, he throws a grenade, and the grenade kills Sergeant Spears. The Marines, in response, shot Omar Khadr 3 times in the chest and then captured him. All of that is in accordance with humanitarian law. I mean, I know I'm describing killing and blowing things up, but this is all in accordance with humanitarian law. But then Omar Khadr gets charged with murder, and to the humanitarian law, this seems like a surprise because combatants kill combatants in armed conflict. To which the U.S. legal advisor's response is, well, normally yes, but not in this war, not with this enemy, because they're unlawful enemy combatants. And the U.S. legal advisor, Bellinger, has said, we had a right to be there and they didn't. So you get this asymmetric situation. When we shoot at you, that is war. When you shoot at us, that is crime. Your side is not entitled to the protections of humanitarian law. Now, at first glance, that might even sound like an interesting or useful idea. Why? Maybe humanitarian law could tilt in favor of the good guys, right? Why can't international humanitarian law give more permissive rules to the side that we're rooting for? And in fact, centuries ago, that is how humanitarian law worked. There was this concept of the just cause. The problem with that was everybody thinks that they're the good guys, and so everybody wants unrestrained rules.